So back to SB 951. You don't really have to do anything about this, but it does have an increase in benefit for unemployment and wage replacement for low-income earners. It basically extends that PFL or paid family leave, and also SDI. And so it's an increase. Currently, it could be as high as 90% for some of those low income wage earners. So let's see here. Bereavement leave. This is something new here in California. It basically is under CFRA. I just forgot the F there, but it's SB 1949. It applies to anybody with 5 or more. This is probably one of the more significant changes besides minimum wage, which we haven't even touched base on yet. They need to be employed with you at least 30 days. They can take up to 5 days off. It can be unpaid. You can request documentation. I'm sure we've all kind of had that employee who comes in and says, my aunt died. And then the next month it's the uncle. And then we have, the second cousin. And it does describe in the bereavement who in the family member qualifies for that bereavement leave. And you can ask for a obituary or some sort of listing if you think you've got a problem employee. SB 1041. I bring this up because this is the hardest thing for employers not to do. Is someone takes time off, and then we're going to talk about a case that even goes more into this, but for example, they don't show back up or they just leave the work site. And so this law is directly related to, I didn't look at the history, but I think it's either the UPS shooting that was in San Francisco or the light rail down in San Jose, where an employee attempted to leave the scene and the employer attempted to stop them from doing that. And now the employer can't prevent you from leaving. And so that seems like, we all have too many laws, but the purpose of that was that person wanted out of there because of the shooter and probably saved their life by leaving. So just don't turn around and terminate someone. SB AB 984, this goes with a lot of contractors or people that do delivery. So there's, it was called Fleetmatics. I think now it's been purchased by Verizon, but it's an attachment that goes into the cars, and it basically creates a GPS system. Typically it runs, sometimes it has its own, but it's real time. And so if you had service techs, you can see where they are. So number one, you need to give notice that you're actually doing that. And I recommend giving written notice and putting it in their file that they've acknowledged that they're being monitored. But there was also a question, if you give this person a car to take home at night, can you track them during that time? And the answer is the employee can turn that off. And this, if you use this technology, you certainly, if we got into a lawsuit, and I'll give you a perfect example where we had an employee complain that they never got lunch. and didn't have time for lunch. And we used the GPS tracking to see that he was sitting at, you know, in and out for at least an hour every day, because we could see where the truck was. Or he was at CVS, you know, for 45 minutes. He didn't have time for breaks. So it is, from a, you know, a defense standpoint, being able to prove or disprove wage and hour. I love this technology, but you've got to make sure that you disclose it, because I'm sure a court, if you didn't do the disclosure, they will not allow me to use that evidence at trial. And that could be the difference between winning and losing your case. Benefits. This is a somewhat employment law, but just a reminder that anybody who has one or more employees, so that's like everybody probably in this room at least, you need to have some sort of retirement or Cal Savers program in place. And that is the final arrangement, and completion of that plan is for 2025. So what types of things? 401k, SEP plans. If you don't have that, then you need to go to Cal Savers, and there's a mechanism for the employer to do that contribution with that. Wage transparency. This is probably the biggest one. So this was implemented because there's a disparity in pay, both in gender, both in race, and that the table, you know, depending on who's offering the raise, you know, it's very classic. You go in for a job interview and you negotiate. They offer 80 and you say, well, you know, I deserve X number of dollars. They've found that white men negotiate better than women. People of color, again, don't negotiate as well as the white man. So what they've done is they've required anybody that has 15 or more employees to post the pay scale. Now, what is a pay scale? For those people who aren't in HR, most positions have a range. So I'll use an example. An executive assistant, you know, you're willing to pay between, you know, $20 an hour and $25 an hour based on their experience and education. And so that needs to be part of the job posting. Now it would probably be electronic. You also need to maintain that information, including the title and the wage histories for employees. And then if you have 100 or more employees, there's more reporting that has to be done, and you have to do annual reporting. But we are not the only state. I believe New York had their law come in prior to us. I believe Colorado has some form of, but a lot of states are enacting something similar to this. The idea is that pay, if you're hiring for a receptionist, it doesn't really matter what the person is as long as they can perform the job, and the wage should not change. Trying to decrease that disparity in who's in the position. Wage and hour, if you have anyone with garnishments, you're going to see new rules come out with the garnishment. A garnishment, for those that haven't done it, that's when a state agency, county agency, federal agency takes a portion of the employee's pay. And so this basically reduces the amount that they are able to take. And that's a mathematical formula. Typically, you'll provide that to the person that's doing the payroll, but you should be on the lookout for that new minimum. New law that doesn't take effect until 2024, but this is kind of the hot, everybody's like crazy about this. You cannot take any adverse action or discriminatory action against someone who uses marijuana, cannabis, AB 2188, off the job and away from the workplace. So how does that work? Well, I think my own personal opinion, I think we have a problem with testing, so that, you know, the testing currently, I think, is about, you know, can pick up marijuana use 21 days out. So, you know, that I think has to improve. And I have heard a couple labs where it only checks within like the last 24 hours. Now, still, that's not as good as like for blood testing, where you go get a blood draw, or you know, blow into a breathalyzer and you get immediate, you know, there's a correlation real time, how much of that substance is in your bloodstream. The reason why I'm spending a little bit of time on this is because there's some people who have positions in their company that are safety sensitive. And you're basically going to say, well, I want no one can use drugs in my company. And so you're going to have to exercise some level of caution with that, because depending on what the position is, and you do random testing and then take action, you could be in violation of this. So you certainly want to, you know, the person that's working at the front desk that tests positive, or you see them out smoking, you're not going to be able to take any adverse action against them. So we're on to notable cases. The big news within the last, we'll say, I think about 10 days, is the Federal Trade Commission. So at the federal level, has sent out a notice that they intend to make a new rule that says no employer can enforce a non-compete against other employees. And that's going to preempt or trump any state law that allowed this. So it doesn't necessarily impact us as much in California, because the legislature and the courts have consistently said we're not going to enforce non-competes, but it's just something that we're going to see developing, I think, more and more. And so I have seen non-competes in agreements here by other attorneys. You may have an attorney here in California that wrote it in. It's probably not enforceable. It's usually kind of a threatening thing. That is an ethical issue for the attorney, not for you. But you'd want to look at that in your language in any sort of contractual agreements you have with employees. Also signed within the last year are regarding sexual harassment and assault. There's been a movement to move away from arbitration in those scenarios coming out of the Me Too, that what would happen is a lot of hush money had been paid by big employers or very vulnerable, we'll say, people who have done the harassing, and they don't want their name out there. And so it has ended arbitration, which is private and no one can find out about it because it's very confidential. And it also, if the woman or person wants to speak out, it eliminates the use of what's called pre-litigation or pre-dispute, telling people to be quiet, kind of NDAs, kind of gagging their ability to talk out about it. So those are two big or three big federal laws that will impact us. There was a case mid-year last year that was about arbitration. It's Viking River Cruises. And it is just another case that if you have arbitration agreements within the next, period of time, you're really going to want to look at, have they been updated? Probably a third of the cases that come out from our courts and in the employment type cases are on arbitration. Arbitration is a double-edged sword. Depending on the type of industry, if you have high turnover, so maybe at any one time you have 30 employees, but throughout the year you hire 500, which I have some restaurants that do that. Having an arbitration could potentially stop a class action. And that could be the difference between paying, $5 million in damages and maybe paying 500,000. It could be a big difference. So it's something to think about. If your industry has a lot of employees in a given year, you're trying to prevent the class action. The other big case this year was, and I had mentioned something to this effect, was the Lawson versus PG&E case. And it basically clarified, when someone whistleblows, what is the standard that the court is going to look at? And the reason why that becomes important is because you really have an employee-friendly standard. For many years, the courts had basically said, we're going to make them kind of go beyond the preponderance of the evidence. And the courts have now pulled back and said, we're not going to use that high standard. We're going to go back to preponderance of the evidence, which means as an employer, anytime that you do something that is potentially, I'm trying to think, they don't use the word substantial, related to, I'm trying to think the other word that they used in that case, that's an adverse action, can prove that allegation that you retaliated against them. And they would get into court and probably win on that. Where's my mouse? A couple other cases I just want to mention. We had a meal and rest break. If you haven't looked at your meal and rest breaks and the timing and how those get reported, employers may now be liable for failing to properly report premiums, as well as waiting time penalties. And so what I want to talk about just for a moment is, when someone misses a meal break, as an employer, you have an opportunity to fix that right on the spot. You can pay for an hour of their premium pay. Now, where it was an issue in this case is they didn't designate that. They didn't report it as premium pay. There was no way to know that that hour that was paid was for that premium. And so my recommendation to you to keep out of this is, if your employees are missing a meal break or a rest break and you're going to pay that penalty so you can avoid a lawsuit into the future, that on the pay stub, you get your payroll provider to say meal break premium, or something to the effect that if we ever had to go back and show for litigation, that you paid that. Oh, the word that I was looking for on the retaliation, the whistleblower activity just has to be a mere contributing factor. So that standard is so low. And then I'll do I think that's kind of I mean, there's always so much more that I can talk about. I know we were out for a few minutes, but I want to be sensitive, and now I want to give people time to ask questions.
Kristen, there is a question in the chat from Kathleen.
Okay.
And I believe you were on the wage page, and her question is, it has to be offered and documented, correct? So maybe Kathleen, you might have to clarify that for her.
It's for the retirement. So I had offered it last year. You know, I have ADP payroll, and I had offered it. Nobody signed up. I offered it again for this year, and nobody signed up. So I had them sign that they're not signing up. Am I okay there?
Yeah, so you need to have them do a declination. It's called a declination. So it's a denial of, you know, and it's nothing magical.
Right. Okay.
And but you're already offering to other employees. These employees are opting out, correct?
Correct. I just have ADP still reminding me every week, you know, you have mandatory, and nobody signed up. Nobody wants to do it. And I don't have to match it. It was just an offer. They could do it on their own through their payroll deduction. That was one question. Yeah, go ahead. Sorry.
I would ask them if there's some sort of reporting they have to do. Like, for example, you know, the law was, it's mandatory, but I don't believe that an employee can't opt out of that. So there may be some reporting that has to happen when you have non-participatory. This is more a financial kind of, I guarantee you a financial planner person would have like more in-depth answers than I do.
Okay. And then on the last call, I typed a question. So the new COVID posters that you have, that you posted up there, is that included in the new California labor, all-inclusive labor law poster?
I believe it is. I believe
so if I have those and I've posted those, I'm golden.
I believe so.
Okay, thank you.
Reminder, as if anybody else has questions, well, those are coming in. A reminder that I would guess most people don't have a $25 million and selling information, but we have the, it's called CPRA, which is the California Consumer Privacy Right Act. And so if you are a company of a certain size and you collect employee data, you're going to have to let people know that, and you sell it, you need to let them know that that's happening because they can opt out of that. And there's also some obligations as far as protecting that data. Minimum wage went up to $15.50, regardless of the size. If you're in other jurisdictions, so for example, if you send an employee into San Francisco for more than, I believe it's 2 days, then you have to meet their minimum wage and the rules that are required for that.
Wow.
Other questions?
So Jen Evans also posted a question, and it says non-compete. Does that include rules about taking customers with them?
Okay. So the law basically has a twofold approach to this. So if you do everything that you're supposed to protect your clients, then the law will support you as far as what's called misappropriating trade secrets, and you would prevail. Typically, when I have clients who take their ex-employees take what's called a book of business, unless it's governed by statute or by contract. We end up sending a cease and desist letter. But the law, that what they're doing is called non-solicitation. And so you almost have to approach it from the other side, is where you say to the customer, when you sign a contract, you know, this is a 1-year contract. If you breach that contract, because you can't prevent the person from having a job. So that's kind of the double-edged sword. You know, you send this person out, they're selling for you, they connect with this person, maybe they don't connect with your brand, you know, ABC, you know, shoes, but they would think that, you know, Sally here is everything, and now she leaves and goes to XYZ shoes. You know, certainly she's allowed to go out and earn a living, but if she interferes with your contracts, then you may have an action. Long-winded answer, sorry.
All right, so Peter Tan has, he wants a clarification. The minimum wage in Livermore, he believes it to be $15.75. What is it exactly?
I'm unaware of it being $15.75. Peter, what makes you think that that's the case?
Oh, because I was just recently looking it up. I think for 15.50 was the it's a California new minimum wage. And then I was looking for each county, and I think Livermore is in Alameda County. I think Alameda County is 15.75.
So I don't believe Alameda has a separate.
Oh, let me see. I'm just trying to find where I found it.
Are you sure it's not the city of Alameda? Alameda?
No, this is the county or city. I found it on paycor.com.
Okay.
And yeah, Alameda, it says here is 2022 minimum wage is 15.75, and 2023 is 15.
Alameda is the city.
Oh my God. Okay.
That's the city.
Let me find Livermore. And it
So
doesn't.
Livermore does not have a pay requirement that's different than.
Ah, my goodness. Okay, that really confused me when they say it's county or city. Then I don't know which one it is.
Well, I just know this well enough to know that that wasn't the county.
Gotcha. Thank you for clarifying.
Yeah.
Yeah.
And the other place that you could look, if you are unsure, is that you go to each city.
Mhm.
You would go to, you know, their website. The same for Alameda.
Mhm. So the city of Livermore.
City of Livermore.
I
City
see.
of
Thank you.
Pleasanton. Okay.
Awesome.
Who else? That was a
We
good
have a
question.
Lorena Oliva. Any chance you can go over the bereavement leave?
Okay.
Disconnected, of course, like everybody did. Apologize.
Okay.
Apologies.
All right. So I'm looking, since I don't have that up on the screen, to give you the so it's AB 1949. It's a protected leave. It's an unpaid leave. If you have 5 or more employees, it allows the employee to take up to 5 days of bereavement upon the death of a family member, including a spouse, child, parent, sibling, grandparent, domestic partner, or parent-in-law. It must be used at least, they have to be eligible first. They have to have worked at least 30 days. They can use vacation time if that's available, or PTO or sick. And you can require documentation, which is a death certificate, a published obituary, verification of death, memorial services, something from funeral home, burial society, crematorium, religious, and the leave must be completed within 3 months of the family member's death. Okay,
All right. We have one more, and it's regarding the premium meal break compensation. Is that for hourly or salary employees?
okay. So that's for hourly employees. So whenever you're talking about in labor law or employment law, you have what's called exempt. And that's usually like it's called salary people. They can work as many hours as necessary to complete the job. And if it takes less hours, they can work less hours. Then we have what's called non-exempt. Those are hourly employees. And so non-exempts meaning they're not exempt from overtime. So they're entitled to overtime, meal, rest breaks, all the labor laws that fit into that.
Awesome. All right. We have any more questions that are not in the chat?
So I apologize. I appreciate the people that came back, our technical issues. Certainly, if you don't have my contact information, it's up here. If you have stuff you need to review, you know, certainly give me a call. We can talk about what your legal needs are. And hope to see you out and about.
Awesome.